Morning, everyone. Thanks for attending this webinar. We're going to wait a few minutes while people are still logging on. If you'd like to connect with today's presenters on LinkedIn, you can do so using the QR code on your screens now. As I said, we'll wait for a couple of minutes for people to join. Okay, I think we've probably waited long enough. So to start, my name's Neil Davies. I'm a partner in the insurance disputes team here at Mills & Reeve. I'm joined today by my fellow partner, Ben Hardiman, and Chloe Poore, an apprentice solicitor. We all deal with construction and engineering risks. Now, as advertised today, we're going to talk about some recent cases involving the Defective Premises Act. Now, it's fair to say the DPA has been given new impetus as a result of the Building Safety Act 2020. And whilst the Building Safety Act has had a huge amount of focus in the last few years for obvious reasons, there have been a few decisions regarding the DPA itself over the last 12 months, which we think are important for people involved in construction risks. Firstly, a little bit of housekeeping. This session is being recorded, and a recording of it will be available afterwards to those attending. Secondly, if you have any questions, please use the Q&A box, and we'll respond to them after the session. We're simply not going to have enough time to do so today. And finally, there'll be an opportunity to provide feedback, but Ben will cover that in more detail at the end of the talk. So with that said, I'll pass on to Chloe.
Good morning, everyone. So the first thing that we're going to look at is what actually constitutes a dwelling. Now, a dwelling is not defined within the Defective Premises Act itself, but it's clear that it does include houses and flats. It was in the case of Caitlin Estates and Carter Jonas that it was stated that a dwelling house is a building used or capable of being used as a dwelling house and not being a building which is used predominantly for commercial and industrial purposes. But flats are dealt with slightly differently, and they were dealt with in the case of Rendlesham, where it was said that an entire block of flats could not be considered a dwelling, because it was obviously incorrect to describe the occupier of one apartment as occupying or sharing the living space in a different apartment. In this case, the court rejected the argument that the common parts and the basement car park formed part of a dwelling, and this is because they are usually covered within a service charge agreement. So Section 1 of the DPA indicates that the provision of a dwelling is achieved through the erection, the conversion or enlargement of a building. However, previous case law suggested that the provision of a dwelling only meant the creation of a new dwelling. But in June 2022, the Building Safety Act completely changed this, as it allowed an extension to the rights under the Defective Premises Act to people who have had defective work completed on an existing dwelling, which meant that conversions and enlargements are now covered. So we then move on to who can actually pursue a claim. Section 4 of the DPA set out that in the Act, the duty is owed to those who might reasonably be affected by the defects in the state of the premises. Now, interestingly, this could include tenants, those living at the property, and their visitors who may actually be affected by the defects. In relation to flats and a student accommodation, although communal facilities do not in their own right necessarily fall within the heading of dwelling, the common parts and structure of the flat may be seen to be constructed in connection with the dwelling and would therefore be relevant if the defects were to impact the habitation of the overall dwelling, meaning that those within a flat under a lease can bring a Defective Premises Act claim. It was determined within the Court of Appeal decision in the URS Corporation and BDW trading case that under Section 1 of the DPA that developers are also owed a duty of care, And this is because the wording of the Act reads as dwellings provided to the order of. And in this case, it was seen that the dwelling was being provided to the order of BDW, and therefore they were owed a duty by URS. So we're now going to move over to Neil for him to discuss further.
Thanks very much, Chloe. So today I'm going to talk about the case of Venka, Marbach Construction, Mercer & Miller and SCD Architects, and two points that came out of that. Firstly, whether the DPA creates strict liability, and secondly, more guidance on what constitutes fitness for habitation. So in terms of the, before we move on to that, so just a reminder really of what section 1 of the DPA says. So it is to see that work is done in a workmanlike manner, or as the case may be, professional manner, with proper materials, so that as regards to work, the dwelling will be fit for habitation when complete. Now, there's been some suggestion that section 1 of the DPA created a position of strict liability. Now, a number of legal commentators suggested that, and indeed even the government guidance accompanying the Building Safety Act stated that liability under the Defective Premises Act is strict. Now, that was in guidance, a fact sheet published in April 22, but it's notable that that was withdrawn fairly quickly, July 22, and has not been repeated. And I think it's fair to say that many lawyers were pretty dubious about the suggestion of strict liability. And we can start by looking at the actual duty. As I said, section 1 of the DPA, and it's a single composite duty. Now that means that failing to carry out work in a workmanlike manner or a professional manner or without proper materials does not by itself constitute a breach of the DPA, unless the dwelling is unfit for habitation. So equally, it stands to reason that if it's a single composite duty, it's necessary for there to be a failure to carry out the work in a workmanlike manner or professional manner as well. So looking at the Venka case, it related to the construction of a residential property. The owners were the claimants, and they alleged a number of defects in construction and a broad claim against Marbach, who were the contractors, the project managers Mercer & Miller, and the designer architects SCD. Now, the claim against Mercer & Miller was settled, but the claim against the contractor and the architect went to trial. Judgment was handed down in March this year. Now, the claim against the architects SCD in contracts and tort time barred, so the claimants had to pursue a claim under the DPA. And whilst Venka did not directly address the issue of strict liability, the judgment clearly suggests that the judge did not assume there was a strict liability when considering the alleged defects at work. So when considering the defects, which are said to render the property unfit for habitation, the judge assessed whether the architects had exercised reasonable skill and care. There are two clear examples in the judgment where the judge assessing whether the architects were liable for failing to spot defects, the judge did so by considering what the architect would have observed had it exercised reasonable skill and care. Now, the first quote on your slide is from paragraph 292 of the judgment, and in the judge's own words, it is, of course, not the case that SCD is liable in respect of a defect simply on the basis that it failed to observe that defect. Consideration must be given to what SCD could reasonably have been expected to observe on a reasonable inspection within the scope of their services. And it's of note that against this measure, the architect was found not to have breached its duty in respect of one of the significant defects alleged. Now, the judge's approach in assessing loss also followed this theme, and it's notable in itself anyway. The architects argued that the claimant was only entitled to the costs of making the property fit for habitation. However, the claimants argued the damages should go beyond that, and they should reflect the original design intent and appearance. Now, the judge found that as one of the constitutional elements of the duty under Section 1 is to ensure that work is done in a professional manner, damages should more naturally reflect the failure to see the work done in that manner. And this meant that the damages were not just the cost of making the dwelling fit for habitation, but also in the way it would have been had the services been provided in a professional manner. And that's the second quote on the slide there. So whilst Venka didn't deal directly with the issue of strict liability, it seems to me that it points to there being no such duty. So moving on to the second issue under Venka, unfit for habitation. Before we start, it's looking at Venker. It's important to stress that the judge in Venker did say that each case needs to be assessed on its own facts on a case-by-case basis. The judge reiterated that and referred to the guidance in Rendlesham, which Chloe's mentioned, as the leading authority, and that still remains the case. So it's worth refreshing ourselves as to what the guidance under Rendlesham said. So firstly, and these are all on the slide in front of you. So firstly, the defects must be considered as a whole. Secondly, the dwelling must be fit for habitation for all types of persons who might reasonably expect it to occupy them. It's to be measured by the standards at the time of construction. If a local authority with knowledge of construction wouldn't approve it as fit for habitation under the building regs, then it probably is unfit. Just because a defect can be remedied at modest cost does not mean there is no breach. A defect can render the dwelling unfit even if the owner or builder is unaware of it. A state of affairs which arises because of lack of maintenance does not mean the dwelling was unfit at completion. But if the need to remedy a defect would make maintenance a waste of money or futile, then the failure to maintain is unlikely to negate a breach of duty. Serious inconvenience may make a dwelling unfit. Risk of failure of a structural element which exists at completion may make a dwelling unfit. And finally, evidence of having to vacate the dwelling to carry out remedial work in breach of standard is relevant. So moving on to the guidance that came out of Venker, there's some useful comments from the judge in the judgment, which we can draw guidance from. There are a number of alleged defects, and it's clear that while some of the defects could not be said to render the property unfit for habitation, some of the defects overlapped, and the judge needed to consider how to deal with those. So in assessing the defects, the judge stated that, firstly, it's relevant to take into account that the property was intended not only to be a new build, but also a modern housing design. Secondly, it's unlikely that a defect that is only aesthetic or inconvenient would render a dwelling unfit for habitation. Thirdly, there may be a breach of duty in respect of a defect, which means that the condition of the dwelling is likely to deteriorate over time and render it unfit for habitation. When it does so, and in that case, a dwelling can be said to be unfit for habitation at the time of completion. And finally, it's appropriate to consider the aggregate effect of the defects when determining whether a dwelling is unfit for habitation. However, the defects which are minor or aesthetic do not contribute to the unfit for habitation and cannot be counted. So one final point in Venker before I pass over to Ben. The architects had a net contribution clause in their appointment, and they sought to rely upon that to limit their liability to the claimants. Now, the judge found that a net contribution clause fell foul of section 363 of the DPA, which rendered void any terms purporting to exclude or restrict liability under the DPA. Therefore, the architects couldn't rely on that clause as against the claimants. With that done, I will pass over to Ben.
Thanks, Neil. Hello, everyone. So I'm going to give you a review of the extended limitation periods and causes of action under the Defective Premises Act, and then I'm going to touch on a case which has already looked at this issue. So you'll see the table on the slide, which I've attempted to summarise the position across the various changes. So the top line, top row, is the position prior to the Building Safety Act coming into force in June 22. At that point, the limitation period for claims under the DPA was 6 years, and that runs from practical completion. Now, as Chloe has explained, that was a cause of action, well, it still is a cause of action, which relates to the erection of a new building only. And the Building Safety Act has made some significant changes, as Chloe has talked about. So the three subsequent rows to consider, which summarise these new rights and time limits. So firstly, for new builds which completed before the Building Safety Act came into force, so that's the Section 1 duty that has always existed, limitation has been retrospectively extended. So instead of 6 years, a claimant now has 30 years. Just to put that into stark terms, it does mean that as at today's date, a claimant could pursue a claim under the DPA if the dwelling achieved practical completion at any time since September 1994. As for the middle row, so this is the BSA's introduction of the new cause of action covering works done to refurbish a building, to extend it, whether or perhaps for remedial works. That one does not have retrospective effect. So we're not looking backwards. It's a new cause of action, but it doesn't relate to works done before 28th of June 22. The position in relation to that, so for any building completed after June 22, that's whether it's a new build or a refurb, remedial works, etc. Any person entitled to bring a claim under the DPA on those aspects has 15 years to do so. So if anyone is about to hit practical completion on a building at the moment, proceedings could be brought all the way through to September 2039. Now, before I talk about the early case law I mentioned, the Building Safety Act has a couple of important carve-outs. Firstly, we've got section 135, subsection 5, which requires a court to dismiss a claim if it breaches the defendant's human rights. Now, we don't know how this will be applied yet, as it's not been properly tested. But Chloe mentioned the case of BDW and URS earlier, and I'm going to look at it in a bit more detail in a moment. But there is a glimmer of light which is given to defendants in that judgment, and there's a single sentence which says that subsection 5 may be engaged if the defendant could show that it had destroyed some critical documents which might have provided a defence to a claim, because it had assumed any claims were statute barred at that time, so at the time of destruction. Now, this wasn't a central pillar, so it wasn't fully analysed. It's just a throwaway remark. But any defendant faced with a claim dating back 30 years might well be looking at when documents were destroyed and the reasons for doing so, perhaps whether any key witnesses are still around or not around to be able to give evidence, and maybe even as far as whether it's possible to find an expert with sufficient knowledge to comment on working practices of events 30 years ago. So, as I say, it wasn't fully tested in the URS decision. I think it's an issue to watch as more older claims are brought. The second carve-out, the second route for a defendant to avoid the DPA lengthy liability is subsection 6 of section 135, and that's that a claimant cannot reopen a claim which has already been settled or finally determined by the courts or via arbitration. In that event, a claim on that basis must be dismissed by the courts. So with all that in mind, the case that Chloe mentioned earlier, URS and BDW, this is a case that the Court of Appeal described as having all the hallmarks of a 3-day examination in construction law. So it was enjoyable to read this judgment in preparation for this webinar. But what the judgment does is to deal with a really quite broad range of issues. And only one of those ties into the issues that I've talked about today, the limitation periods. And that's what I'm going to focus on now. So firstly, was BDW's claim under the DPA brought in time? And secondly, what about its Contribution Act claim arising from the fact that BDW said it was liable to the individual purchasers or leaseholders? So by way of background, it's a claim relating to a number of tower blocks developed by BDW, whose structural engineer at the time was URS, or a former URS entity. Now, before any problems arose or issues were raised about the tower blocks, BDW had actually disposed of its interest in the development. Now, despite no longer having any proprietary interest in the buildings, BDW said it was appropriate for it to act as a responsible developer when those problems arose, and so it incurred significant costs to investigate the issues that had been raised. Those investigations revealed significant structural issues, So BDW carried out both temporary and permanent remedial works. It then commenced proceedings against URS to recover the costs it had incurred. Now, the proceedings it issued were brought before the BSA came into force. Now, at that point, given the time that had passed since practical completion, the DPA cause of action was not pleaded because it would have been statute barred. BDW's claim in contract was also already statute barred, as was any claim from the owners of the individual flats. So that precluded a claim for contribution. So at that point in time, BDW's only cause of action was in tort. The BSA then came into force in June 22, and BDW applied for permission to amend its pleadings so as to introduce claims under the DPA and under the Civil Liability and Contribution Act 1978. Now, since the limitation period for the DPA claim had been retrospectively extended, as I've talked about, the TCC found that BDW's amendments were reasonably arguable, and so it granted permission, and that was what URS appealed. The Court of Appeal rejected URS's argument that the retrospective effect of the extension of the limitation periods for bringing claims under the DPA should not affect parties who were involved in ongoing litigation. The wording of the Act was clear, and as you can see, it's on the slide in the middle there. The longer limitation periods available to litigants are to be treated as always having been in force, and the Court of Appeal said that provision could not have been any clearer. Now, I mentioned the carve-outs for defendants earlier. There was no such carve-out in relation to ongoing litigation, and the Court of Appeal said that Parliament could have allowed for that if that was their intention, but they did not do so. Therefore, the claim could be amended to add in claims under the Defective Premises Act. As to the claim in contribution under the 1978 Act, URS's argument was that no claim had been made or intimated by the individual leaseholders, and or it had been finally determined by BDW having carried out works. Both of those arguments were rejected by the court. In short, the Court of Appeal determined that the Contribution Act provides for any such liability which has been or could be established. So that says that a claim does not have to be made for the right of contribution to arise. And further, the Court of Appeal said BDW's liability to the leaseholders would be assessed at trial. Since that would be after the Building Safety Act, the leaseholders themselves would benefit from the extended limitation periods. Their claims would not be statute barred, and therefore BDW would have the 2-year limitation period under the 1978 Act to pursue URS. So the claim was not statute barred. So just to wrap up and take you back to the title of our talk today about whether the DPA is coming out of the shadows, I think it's clear to us on this webinar, but also those practicing in our construction engineering practice, that we are seeing more claims brought under the DPA. I think it's underlined by the case law we talked about in Vainica that Neil talked about. Although the claimants didn't succeed on every count, they couldn't have succeeded in a claim against the architect without those changes brought about by the BSA. And the same goes for BDW's claim against URS. It did have a cause of action in tort, but I'm sure its position will have been bolstered by the court allowing the amendments for the DPA claim. So I think the impact of limitation being extended does mean the tide has turned. We are seeing claimants being prepared to pursue claims under the extended limitation periods, which would otherwise be statute barred in contract and tort. Given those claims may extend back for 30 years, underwriters will no doubt be thinking and carefully considering how this could impact on the insureds they look to write who have operated in that residential space over that 30-year period. On the contractor or consultant side, you'll no doubt be seeing changes to contractual terms being proposed. So you'll see terms trying to bring the contract in line with the limitation periods. You'll also need to think about the sorts of document retention issues that I raised in the URS case earlier. So that's it for our breaking ground session today. Thank you very much for coming along. We've actually not had any questions so far. I think you are able to provide questions within the feedback if you want to, and we will do our best to respond to any that you provide. Watch out for updates with details of the next Breaking Ground webinar, which will be coming out shortly. And as I said, and as Neil said, please do provide us with feedback. You will get a feedback form when you log off. We really do value the feedback you give. You are able to propose topics that we may not yet have talked about, and we'd love to try and cover those off. So thank you very much for joining us today, and enjoy the rest of your day. Thank you.